I was on my toes. Good morning.
Good morning, Your Honors. May it please the court. My name is Allison Terry, and I represent the appellant, who is the father in this matter. And I'd like to reserve 5 minutes for the vote. Okay. This is the 7th appearance before this court of these parties. The father appeared to appeal the final judgment of paternity, and Judge Volante wrote his opinion reversing parts of the visitation or time sharing schedule or requirements. And Judge Kelly was also on that panel, so I thought that was pretty interesting. The father now appeals
I didn't sign the search warrant, right?
The father now appeals the denial of his petition for modification of his child support obligation. The general magistrate denied the petition based on his unclean hands. Now, first of all, unclean hands is an affirmative defense. It wasn't pled for. She didn't file an answer to the petition. So that's error. And secondly, to have unclean hands, you need more than passive acts of not paying your child support, or the other 2 instances where the father allegedly said he was going to make the mother's life miserable, and he allegedly created a website that had her picture that said, "Don't get conned across it." There was no evidence presented at trial, you know, who actually did that website. It was just the mother's belief that the father had created that website.
And did the, my recollection is the special master was also influenced by the timing?
Yes, that was interesting because he thought it was suspect that it became, that the petition to modify was filed 5 months after the final judgment. And the final judgment was
so you didn't account for the time between the final hearing and the final judgment.
Which was 6 months, which was, so it was approximately a year after the final hearing that the father filed his petition for modification. And this was 8 months after he lost his job. So he actually lost his job before the final judgment was even in. So he waited 8 months to file his petition because he couldn't find a job and he needed some relief. And he had the right to do that under 61.131A. And I think it was error on the judge's part, or the general magistrate's part, in finding that it was suspect to have filed it within 5 months of the final judgment. That doesn't give him unclean hands. And the unclean hands finding tainted the whole entire proceedings. It made it so the Overby test wasn't even really given a good shot because they found it was not in the child's best interest for him to attend school. When in Overby, under Overby, when there's a 5-year-old child that could benefit from education, that's what should be examined. In Overby, there was a 16-year-old and a 10-year-old child that would not have benefited from their father attending law school for 3 years because one would have reached majority and the other one would reach majority soon thereafter. And that's not the case here. Here, the father had Herculean efforts trying to find employment. He sent out 1,500 resumes, had over 300 interviews, had 50 times where he was almost hired. And he just, after 3 years, he gave up and thought, I'm just going to go to school and try to, or actually it's like 2 years. After 2.5 years, he said, I'm going to give up and get some more education so I can get a better paying job. And these circumstances do not equate to unclean hands. Unclean hand requires that the father's proposed misconduct exceeds mere negligence, that the mother relied upon the father's misconduct, the misconduct relates to the litigation, and the purported misconduct harmed the mother. Here, there was nothing showing that it harmed the mother because she actually received a raise and a bonus during the time period that's relevant.
Well, counsel, in terms of the unclean hands situation, I mean, aren't there cases, at least in the family law area, which basically where the courts have held that if one parent goes into arrears and doesn't pay the child support, and the trial judge can find that they had every adequate means of complying with the child support order, with the order of the court, and didn't. That equates in the family law area with unclean hands, and the findings of the trial judge in this case indicate that the trial court believed that the father had the ability from day one to satisfy all of these obligations.
I disagree with you respectively, because unclean hands requires more than an inaction of not paying your child support. It requires an affirmative action. And in this case, the parties had an agreement as of April 2018 that in exchange for the father getting up to date on his child support payments and signing a quadro, that he would not be paying child support until resolution of his modification proceeding. This was entered into a stipulated order. So finding that the father had unclean hands when the parties had an agreement that he would not be paying until resolution of the modification proceeding.
Well, wasn't there a date certain given for that modification proceeding? I know it didn't, the hearing did not happen at that time.
Correct.
The order did come out, but there was a provision that it would only be waived until that June 19, the June date. And after that, if the hearing didn't happen, and here the father came up with the windfall of money, and he didn't use it to pay his child support.
When he sold the property, that was in March of 2019, he was up to date on his child support payments. So there was no need for him to use any of that money for child support payments. And in addition, since the time of the filing of the modification petition, the father paid over $71,000 of child support to the mother. So, and this was a time when he was unemployed. So the fact that it's a direct payment or an indirect payment shouldn't matter. It is there. She is receiving child support payments. Unclean hands just is not appropriate in this case. It tainted the entire proceedings, and this court should reverse on the unclean hands finding and remand for the court to determine if his unemployment is involuntary, which it was undisputed that he was let go from Dell, so that's not in dispute. They tried to dispute it in their answer brief, but it was not disputed below. There are also two other issues that were conceded on by the mother in her brief. There's a $10,088 credit that the father was entitled to, that the parties all agreed. And I'll give you those record sites. With T586, that the father was owed a credit of $10,908. And the other issue was the parties agreed to take the child care costs out of child support guidelines. Now, at the time of the final judgment, the child support, the child care expenses totaled $900 a month. And that can be found at 1381 of the record. The parties stipulated to take the child care expenses out and pay their prorated basis. That is found on T548 and 549 of the record. And this was not disputed. These two items were not disputed. So since the whole unclean hands tainted the whole proceedings, this needs to be remanded for a determination of whether it's voluntary. If it's voluntary, they should impute income to him. But there was nothing at the hearing regarding any job that was available to the father, and the father had just a great effort of sending out over 1,500 resumes and having 300 interviews, and 50 almost got hired. And that's why he attended law school, because he couldn't get it in law school. That's why he's attending, getting his master's in computer science to further his career. And I think it's interesting that that the Florida Supreme Court in Overby acknowledges that today we live in a changing economy that often requires new or enhanced skills to ensure that individuals may continue to earn wages at commensurate or increased levels. So I think that's exactly what happened in this case. And like I said, the child here was 5 years old at the time of the modification proceeding and would benefit from this 3 years of education, which he was halfway through at the time of the modification proceeding. So we only had 1.5 years left.
Yeah, I do have a question. I want some clarification about your argument on the child support expenses. You said that there was an agreement that they would be outside of the child care payments, that they would be outside of the child support. So are you arguing that the $1,900 a month child support payment ordered should have been lowered by the $980?
Yes, the $900, it should have been removed from the child support obligation. That wouldn't be all of his because she's responsible for 30% of it, I believe. It's 70-30. So yeah, 70% of 900 should be instantly removed.
Just his pro rata.
Just for that, just his pro rata.
Just his, okay.
So
I just wanted to understand that.
Also, the court seemed very upset with the fact that the father was remaining and living in his condominium, which he had lived in since it was his homestead, and he had lived there.
The court or the general magistrate that found these findings that the circuit court judge approved? Because the magistrate used the word "didn't come with clean hands." I mean, is that where the unclean hands came from? The magistrate?
Yes, it's all from the magistrate.
Okay.
It was error for the trial court
to adopt and approve it. But wasn't there things in the magistrate's recommended order that seemed to be credibility driven? Maybe he misspoke. Maybe if you take out the clean hands and the unclean hands theory, do you have enough there for the trial court to be affirmed?
No.
You said change the whole thing. But we send it back and say, redo the whole thing. You can't use clean or unclean hands.
Or you can find that there were no unclean hands, and that him being unemployed for over 2.5 years at the time of the modification proceeding, while he was actively seeking employment, was permanent in nature. And because did
the magistrate make any findings on that issue by itself? No. Went right to the clean. I don't care. I'll listen to you. You got unclean hands.
Yes, that's what happened.
It's unusual to see that. I haven't seen that.
Yeah, and you're still living in your penthouse.
Yeah, he's living in his penthouse, which is he's on the top floor of a building that, according to the judge, was considered a penthouse. Even though technically to have a penthouse, you can only have 4 apartments on the top of the floor. So, but whatever. But and also he was behind $23,000 and for payment of his penthouse. He was struggling. He was borrowing money.
But the magistrate also said he only paid child support when it was intercepted by things like the IRS.
The record does not support that.
And that's opposite of what you were saying.
Yeah, the record does not support that.
But where'd that come from?
I do not know.
Okay.
It's probably because most of the money was, or a great deal of the money was intercepted. So, but,
well, counsel, some of the money did it come from the fact that some of the money he paid was, I guess, a quote direct payment outside of the structure that the child support payments were supposed to be paid.
Yes.
I think that's what your $10,000 credit is
yes,
seeking.
Yes, Your Honor. So I'm going to rest.
All right, that was good timing.
Thank you. I thought it was about there.
Yeah, 75 minutes.
Good morning. May it please the court. Angela Weiner on behalf of the appellee Brittany Taft Heller. As the court is aware, this is these parties' second time visiting you. Of note for the court, the parties have been in constant litigation since the month the child was born. over 7 years ago now, and I guess there's no end in sight. But with regard to the denial of the supplemental petition, the magistrate ultimately really boiled down to credibility findings about the father's testimony with regard to his ability to pay, the fact that he really did come to the court with unclean hands, even prior to
what's your response to the argument that that wasn't pled, that had no place in this proceeding?
It was tried by consent, Your Honor. As the law has long been established, a party may raise issues at the time of trial. Litigants can conform to the proofs as long as there's no objection raised. And there was no objection raised in the trial court before the magistrate with regard to these issues not being fully pled in writing. But they were actively tried. They were clearly part of the presentation at the time of trial, and they went into the record with no objections asserted. Now, to the contrary, the father tried to raise new issues at trial that were not pled, not part of his pleadings, such as the changing circumstances with regard to his newfound voluntary decision to pursue a graduate degree. That was objected to at the time of trial. Clearly in the record, that was objected to as a basis for modification, as well as seeking a modification based on the mother's modest increase in employment. And mind you, with the same company, just a slight pay raise, more of a cost of living raise. But even without the unclean hands argument, which I do think is really important in this case, because the magistrate did make a very specific finding, and it was even contained within the father's supplemental petition. He was seeking the court to look not just at the modification of the amounts in the final judgment, but he was seeking it retroactive back to a temporary award that predated the final judgment. At the time the supplemental petition was filed, there was still the initial appeal pending for this court on the final judgment, which I don't believe was resolved until a little after, or a little less than a year after the supplemental petition was filed, which I think, complicates the record a little bit, but for all intents and purposes, father has never been compliant with any child support order from prior to final judgment through and forward. And I think the important thing to look at too is that the magistrate made clear and clean findings. The father had the ability to pay. He had assets that he could use to satisfy the child support awards in full. Now, notably, things that are not raised by the appellant today are father's other alleged efforts prior to seeking this new graduate degree. He created a startup company. He pulled money out of his retirement accounts for that. He was able to put funds forth to do things, creating a hard coffee startup company where he even pursued international travel and vendors to help facilitate that. He also allegedly worked for a friend on a commission type of, I guess, salary is the best way to put it, for over a year, but claimed that there was no income ever made despite this long time of employment. And relying on Overby when it comes to, again, the not-pled voluntary choice to pursue this education, father didn't seek a temporary modification because of this education. He was seeking a permanent modification. And I think that's really significant in this case because one, father didn't present the evidence that would show how this degree, if obtained, would impact his future earnings. And two, the true time to recoup and why it would be in the long-term best interest of the child. The father didn't present that evidence. He didn't seek anything other than telling the court effectively, well, I'm going to go get this graduate degree because I think it would help me get a new job.
Well, counsel, one thing though that the father did plead was that he had been laid off by his employer and he had been unable to secure employment despite his efforts. And because of the finding on unclean hands or for some other reason, the trial court never addressed whether the unemployment was voluntary or not. So we're kind of left to guess at what the magistrate found, how he resolved that issue, and that was an issue that was pled in the pleading.
Well, I think the magistrate does resolve it, just maybe not as clearly in the findings as would be helpful for all of us looking at it in hindsight. I think that's where the magistrate, and I believe it's really kind of clear if you take the transcript coupled with the report and the amended report, where the magistrate referenced the suspect nature of the short time between the entry of the final judgment and the newfound supplemental petition. I think that's really where, and I think it's clear if you read the record as a whole, that is where the magistrate kind of derived that information from, is that the father's not happy with the original final judgment. It's on appeal, doesn't like it, and turns around and files a supplemental petition, now allegedly without the ability to support himself. And even at that point, even though the father does assert that he lost his job prior to the entry of the final judgment, in the gap between the final hearing and the final judgment, even at the time of filing the supplemental petition, it still hadn't been a year. It's not that he spelled out in his supplemental petition his detailed and extensive efforts of any variety to obtain any type of meaningful and consistent.
Are you saying he has to do that in his petition?
I don't think he has to do so fully, but I think he does need to assert at least that he.
Well, what's the point of like the hearing? I mean, doesn't what's presented at the hearing count?
Well, he presented evidence that shows applications that were reduced and minimized to, fit multiple on a sheet, but he doesn't clearly testify of all the meaningful and true effort that these were comparable employment positions or positions he was qualified for, or even positions that would have been an alternative to his prior employment. And additionally, he did have employment. He created a startup, and that was voluntary choice of the father, during the pendency of the supplemental petition, that he didn't take a job, any job, or even apply for anything of any nature that he was able to get. He at some point just stopped seeking employment and created a startup. And then there goes to this other job where his testimony is that he didn't make any income, but that he did work at it, his friend's company, for quite a period of time. But again, the burden is on the father to show how he was, number one, and that he was not in the position that it was a substantial change, that it was permanent, and that he really was not in the position to be able to make the meaningful income that he was making. And even with regard to the education and the benefit of the education, even for argument's sake for the moment, it had been tried by consent, which again, it was objected to. He never presented that evidence how his graduate degree would increase his income or earning potential, or that there would be available jobs that he would be able to get once he graduated with that degree that would put him at the same level or an increased financial level than he had been prior to the loss of his Dell employment.
So let me ask you a question. If we find error in invoking the doctrine of unclean hands, whether it was preserved or not preserved, the magistrate shouldn't have pulled in cases from out of state, 1973. I think there's one 2005 case. Where did that come from? But let's take that out of the formula. Can this be affirmed without the unclean hands?
I believe it can.
Okay, tell me why.
Because a couple factors. The father's evidence did not meet the simple prongs when we're seeking a modification of the child support.
Well, did the magistrate make the requisite findings, or did, as Ms. Perry says, unclean hands taint the entire proceeding? He's got to do a redo.
I don't think the unclean hands tainted the entire proceeding at all. I think it is within the scope of the findings. I think it can be read together, what did occur and what the magistrate saw and what resulted and how the magistrate got to where ultimately.
Well, you know, the thing that I'm thinking about, this is, a lot of it's hypothetical, but it's reality. Let's say you have a new magistrate. They come in, I'm gonna do unclean hand, I'm gonna cut this off in a bit, just like you can't file a writ if you're a prisoner, if you have 5 or 6 bites, we cut you off, we do a cut off. It's gonna have a chilling effect on litigation. People who might lose their case, don't even wanna bring a case because unclean hands, it's gonna be a problem. It sounds pretty bad, oh, you got unclean hands, but is that a concern that we should be concerned with in this case?
I don't think you should be concerned with in this case. Simply put, the father had the ability to pay all along, and I think that's an important distinction.
Well, he loses. Just say you lose. If you didn't carry burden of proof, you don't have to come in with unclean. You didn't need unclean hands to say you lose because there's no change of circumstances. You're crazy for doing this. It's insulting. Whatever you want to say, but you don't have to go the extra yard and use these 30, 40, 50-year-old cases to say you lose because of unclean hands.
Well, I think in this situation, why that finding really mattered, and I think you do see it more in cases where there's constant litigation and a party truly had the ability to do something and failed to do it. I think it's important because it disincentivizes parties to act in a manner just to have the upper hand. You know, you're the financially superior party and the other party's at the deficit. If you keep filing these actions and asserting these changes in circumstances and the other party can't defend it, can't afford to defend it, then what? Then from the public policy.
You go to collaborative law, I guess. Oh, all right, I got it, thank you.
What about the credit argument on the, I guess it was 10,000? You can probably give me a dollar amount.
I believe it's $10,547 thereabouts. The issue with the credit, though, is not ultimately related to the supplemental petition. That credit goes to the contempt, and maybe that clouds the issue a little bit for this court to really see what happened, because both the denial of the supplemental petition and granting a mother's motion for contempt are contained within one order, because I believe it's paragraph A of the order is denying the supplemental petition, paragraph B is granting the motion for
contempt. They're both subject to this appeal, correct?
They are, but the credit, the numbers and amounts at that point, even if the credit were determined, there were subsequent hearings related to the actual administration that are not part of the order on appeal with regard to the payment because of father's wish and request to try to satisfy his purge with obtaining funds from his retirement account. So based on the fact that the unclean hands, which was an issue that was tried by consent, with regards to father's failure to meet his burden on seeking a modification, we believe the trial court original order denying father's supplemental petition should be affirmed. Thank you.
Thank you.
First, unclean hands was not tried by consent because the unclean hands was never mentioned until the report was issued.
So, yeah.
So that's off the table. I also know nowhere in the record where the mother objected to the father's schooling or the increase in the mother's income.
Can I just interrupt the report comment you just made? Did you file for rehearing? Did you file objections? How did that go?
They filed for exceptions.
Exception, sorry.
So I believe they filed for exceptions.
And there's a new rule coming down the pike about
motion to vacate.
What is that?
I don't know. I've just got my first one. So.
Okay. Well, it doesn't apply to this case, but that might have cured this problem. If there is a problem, it might not. We don't know at this point. It's just something I've never seen this unclean hands thrown in like that.
So I don't know anywhere in the record where the mother objected to her, them talking about the father's schooling as grounds for modification, nor was there an objection to the mother's increase in income. Her income increased over $1,500 a month. And it's the child's right, it's the obligation of the court to make sure the child's receiving the correct amount of child support from his parents. That's statutorily required. As of March of 2019, the father was paid in full. This is 18 months after he filed for his modification petition, and also 2 years after he had lost his job. Remember, there was an agreed order in April of 2018 saying, hey, we're gonna wait until the resolution of this case. There was a date on it, but it didn't say, unless this date doesn't go forward, then you're gonna have to start paying.
All right, counsel, assuming arguendo, as they say, that this court agrees with your argument on unclean hands, and that there needs to be additional findings. Would there need to be an additional hearing, or could these matters be resolved on the transcript that you already have?
I believe it could be resolved in the transcript that we have, because father requested that he be imputed minimum wage income along with his rental income. So he would have like $34,000 a year would be imputed to him.
I mean, like, we can't make that finding, obviously, but if we send it back.
If you send it back, you can do something. I also wanted to bring up one a case of unclean hands in the family law case. There was one cited in the report, but in that case, the father took all millions of dollars and got rid of it so he wouldn't have to pay child support. That's a kind of affirmative unclean action you have to do to be deemed to have unclean hands. So
your argument is these mean acts would not equate to unclean hands in this
no,
situation?
they do not equate to unclean hands under any stretch of the imagination. I also asked that the mother filed a motion for appellate attorney fees, I believe yesterday or the day before yesterday, which was way past its due date. I asked that be denied or stricken. I filed a motion to strike